What is up, ladies and gentlemen? This is Ads, coming to you live from Buffalo, New York. Mr. Shrimpsuit is out and about with a female friend, skirt chasing. So I'm the lone king of the castle and the responsible adult one for this particular show. And I wanted to talk more about Julian Assange. I think it is a case and a story that is being underrepresented in our media at large, even the alternative media, I would say. And because of that, I wanted to focus more on that and give people updates on what's going on. I'm on one of these lists, and people can go to assangedefense.org/live-blog or just assangedefense.org for more updates as well. But I just want to take it back to day one. Tomorrow, the trial is resuming. It's Sunday today, the 20th of September. Tomorrow, the trial will resume Monday morning. So I just wanted to take it back to the first day, which was the 7th of this month. Over in the United Kingdom and London, there have been protests going on against the extradition of Julian Assange, as some may know. And to repeat, NGOs' access to Assange hearing was revoked. The judge's name, again, is Vanessa Bereitzer. She announced that some 40 individuals were granted remote video access to the proceedings by mistake, and their access had been revoked at that time, the 7th, which is day one now. And Courage, which is, I guess, one of the sources here, learned that those whose access was rescinded included representatives from Amnesty International and PEN Norway. PEN Norway, I actually don't know what that is. I'm guessing that is another NGO of some sort that was given access to the trial, but then it was revoked. PEN International. I'm quite interested. Looks like some sort of free expression company. International. Looks like they're based in London, though. But back to Assange, RSF, which is another NGO. Rebecca Vincent attempted to deliver more than 80,000 signatures supporting Julian Assange to the UK government and was rebuffed by authorities there. And the judge, again, her name is Vanessa Bereitzer, had this to say. She said, "I know that others are attending this hearing remotely and in an adjacent courtroom. I'm allowing this to take place for social distancing, and technology allows us to watch this remotely. Those who attend remotely are still bound to the usual rules relevant to court hearings. I remind you that it is a criminal offense to record or broadcast any part of this hearing, including screenshots on any device. As you know, I am aware that a photograph has been taken of Mr. Assange inside our court and shared on social media in breach of these rules. I've received a list of 40 people who wish to attend this remotely by cloud. This is something I can consider, but only after I have received an application. I have granted a number of remote access to lawyers and a small number of people, including lawyers who have acted for Mr. Assange in closely related proceedings. In error, the court sent out to others who had sought access. During this pandemic, there have been changes about how people can access proceedings. I remain concerned about my ability to maintain the integrity of the court if they are able to attend remotely. Normally, I can see what is happening in the courtroom to ensure the integrity of courtroom is maintained. Once live streaming takes place, the court cannot manage this breach, even less so when the person is outside the jurisdiction. I want to make it clear that the public interest in allowing remote access is unlikely to meet the interests of justice tests. There are many jurisdictions allowing travel to the UK during COVID, so lessening restrictions on travel. For those who consider they still not traveling to the UK to attend the hearing, then they need to apply again, and I will consider it. I regretfully refused the current remaining applications for access to the cloud access. Regretfully. Either do it or don't do it, woman. Don't do anything regretfully when you're a judge. Among those denied were parliamentarians of London as well. And this is according to WikiLeaks editor-in-chief, Christine Rafnson, and he has been giving updates to the media as well on site outside the Old Bailey in London. And the defense asked that the witnesses be permitted to be taken through their witness statements so that the court, Assange, and the public would hear the evidence in full before cross-examination started. To plunge into cross-examination would not assist yourself, the public, or Mr. Assange, and would not be fair. The prosecutor, James Lewis QC, opposes this, saying it is contrary to divisional court jurisprudence and that it would allow witnesses to give additional evidence beyond their written statements and require constant adjournments to allow the prosecution to consider the evidence given on the stand before cross-examination can begin. The judge decides that each of the witness statements will be made public. Mr. Assange has been given a copy of those witness statements. In my view, there is no benefit whatsoever to allowing the witnesses give evidence in chief. I will give the witnesses time to settle and orientate themselves and will allow no more than 30 minutes. So that's good news. A superseding indictment in this case came well after the proceedings were underway. 6 months after opening submissions, 18 months before the hearing started, and a matter of weeks before the matter was listed, the United States announced a new indictment. Defense counsel Mark Summers, QC, says it is a curiosity that the United States had in previous hearings been content for the hearings to go ahead in February and in May, knowing that this was coming. It wasn't immediately obvious what had changed. Of course, the conduct outlined in it, but as far as the charges in it, it was difficult to discern what was going on. It became clear to everyone on 21 August, just over 2 weeks ago, whether or not we were justified in thinking the charges had changed. The material was expressed now not back, but was being put before you as a potential standalone basis for criminality. That is to say, that even if the U.S. court rejects in their entirety the existing Manning allegations, Mr. Assange can be extradited and potentially convicted for this conduct on its own. And this is a resounding and new development in this case. The reason I am on my feet is, of course, the timing of this development. And again, that was defense counsel Mark Summers. The defense also outlined the various other criminal allegations now included in the new indictment, including assisting a whistleblower attempting to evade arrest. And that is in reference to Edward Snowden. It would be extraordinary for this court to be beginning an extradition hearing in relations to allegations like that within weeks of their announcement without warning. And even more extraordinary to do it in circumstances where the defendant is in custody. To remedy this issue, the defense proposed that the court excise the new conduct alleged in the newest indictment. It is impossible for the defense team to deal with the allegations being put to him, and in relation to material for which you have been provided no explanation for their late arrival. It is fundamentally unfair to introduce separate criminal allegations without notice, without time to prepare evidence, where the defense cannot properly deal with the new aspects of the case. What is happening here is abnormal, unfair, and liable to create real injustice if it is allowed to continue. The appropriate course is for the court to exercise its powers to excise the new allegations. And of course, we went over that last time, that the judge refused to excise the new conduct alleged in the newest indictment. And Judge Baritzer, again, Vanessa Baritzer, said that the defense should have asked for more time despite Assange still being in custody. If conduct is to be excised, she says, it must be in the context of a statutory bar or abuse of process argument. The judge refuses the defense proposal to excise any new conduct in the newest superseding indictment. Because there's a picture of her. There she is. She's on the left here, Stella Morris, and next to her is lawyer Jennifer Robinson. And this is a picture of them arriving at the Central Criminal Court, Old Bailey in London. And once again, the defense requested adjournment. The judge denied the defense's request for adjournment. And we already went over about how Mark Feldstein testified. He's a journalist, historian, and professor from the University of Maryland. Feldstein went on to say a quote such as this: Pulitzer Prize winners and some of the most respected journalists in the nation make a career of basically leaks of classified information. Goes on to say there are so many of them, thousands upon thousands, it is routine. Every study in the last 60 years has said that leaks of classified information inform the public about government decision making, but they also evidence government dishonesty. And they go back to George Washington's presidency, which I think is true. And let's move on. This is day 2, September 8th, 2020. Again, the trial resumes tomorrow, Monday. This is Clive Stafford Smith, who is a US-UK dual national and the founder of Reprieve, which defends prisoners detained by the United States at Guantanamo Bay and others in secretive detention localities on the world. He testified about the importance of WikiLeaks material in their litigation. He first discussed the utility of WikiLeaks disclosures in litigation in Pakistan relating to drone strikes and the sea change in attitudes towards U.S. drone strikes in Pakistan. That's pretty fascinating. There's a company which main purpose is to defend prisoners detained by the United States at Guantanamo Bay, as well as other secretive detention facilities and black sites around the world. Regarding rendition, assassinations, and torture exposed in the WikiLeaks documents, Stafford Smith said, speaking as a U.S. citizen, it is incredibly important that it is stopped. I feel my country's reputation was undermined and criminal offenses were taking place. The litigation in Pakistan would have been very, very difficult and different if it weren't for WikiLeaks disclosures. The most disturbing thing is that the assassination program with respect to terrorists leaked over to narcotics. They were targeting people for death for their involvement in drug trade because it was seen as funding terrorism. That is quite interesting, because then you could basically send out political hits and assassinations simply because someone is in the drug trade in some facet, which basically is what these cartels and criminal drug syndicates do. He goes on to say that assassination programs are not only unlawful, but morally and ethically reprehensible. And journalists being targeted in war zones by the US is deeply troubling and a monumental criminal offense. The defense questioning then turned to the importance of WikiLeaks releases on Guantanamo. He says, "It is difficult and hostile sometimes. This is one of the cases I have received death threats for." Yeah, we tortured some folks. So this guy, founder of Reprieve, Clive Stafford Smith, has received death threats for representing this people. But he goes on to say that your problem is always twofold. The prisoners in Guantanamo don't know what they are charged with. And second, and unfortunately, people never get to meet prisoners in Guantanamo and judge their credibility. So proving what happened involved more than just saying it, but traveling around the world and gathering proof. Stafford Smith explained that it's complicated as to whether the GTMO releases are positive or negative. Those leaks are the very, very worst that the U.S. authorities confect about the prisoners I have represented. But on the other hand, they are really important because the world didn't know the allegations that were being made against my client. The best example I am able to give you, I was frustrated when I first read those WikiLeaks documents because I thought they would leak what I get to see. What was useful was the 13 pages that the U.S. government alleged against my client, which up until that point, I couldn't discuss it with anyone. And finally, I was able to declassify their assertions and prove that each of their allegations was total nonsense. No one has been ordered for release in America, but it was certainly helpful to be able to disprove it. I found it immensely frustrating that the world didn't know about the unreliability of the evidence against my clients. What others have done by taking the WikiLeaks documents, and I credit here Andy Worthington, is to analyze the number of times certain informants were named basis for detaining prisoners. He goes on to speak about enhanced interrogation techniques. I have had a project of comparing the methodologies that my government uses on my clients to what they used in Spanish Inquisition. Hanging people by the wrist while their shoulders, oh my gosh, slowly dislocate. The first thing I do is to apologize. As you go through the documentation WikiLeaks leaked, there are all sorts of things identified, including where people are taken and renditioned. And that was the case in Binyam's case. Clive Stafford Smith says WikiLeaks and those associated could be subjected to U.S. sanctions under the new ICC sanctions regime because of the role WikiLeaks has played in the accountability efforts of U.S. officials involved in war crimes. And here's a picture of Ed Fitzgerald for the defense in Julian Assange's extradition hearings. No, I'm not. Let me get this. Another courtroom sketch. So Ed Fitzgerald, and there's Assange behind him. Wanted to show that. And then here is picture of Mark Feldstein. Again, he's from the University of Maryland, Merrill College of Journalism. He testified the day before. I find it interesting that it was Obama who decided not to prosecute him, but then Trump went ahead with it. It doesn't seem to make as much sense as you'd think, but we had talked about the Rohrabacher connection and his connection to Mike Pompeo, and Mike Pompeo basically seeming to be wanting Assange's extradition, very much so, and some had speculated that it was actually Mike Pompeo's doing and not Donald Trump's. But it's hard to say for sure, but there was evidence for that, as we went over before in the first broadcast. So in 2013, an article written by Washington Post began by saying that the Obama administration's Justice Department has all but concluded it will not bring charges against WikiLeaks founder Julian Assange for publishing classified documents because government lawyers said they could not do so without also prosecuting U.S. news organizations and journalists. In 2017, by contrast, the FBI wanted a head on a pike. President Trump wanted journalists in jail. Then CIA Director Mike Pompeo, there he is, called WikiLeaks a non-state hostile intelligence agency. And then Attorney General Jeff Sessions made Assange's arrest a priority. Even in this administration, the decision was controversial. This 2019 Post article explicitly names James Trump and Daniel Grooms as federal prosecutors who disagreed with prosecuting Assange under the Espionage Act because it was so susceptible to First Amendment and other complicated legal and factual challenges. The prosecution attempted to show that WikiLeaks, Assange, and his lawyers believed charges were still coming. But Feldstein said that while, of course, lawyers would protect their client, and while WikiLeaks would likely always fear charges, the proof is in the pudding that the Obama administration did not bring charges and Trump did, with no new evidence coming forward in between. In answering closing questions, Mr. Feldstein was very clear as to why he believed the prosecution of Assange was politically motivated, citing several reasons: the unprecedented scope of these charges, the fact that a prosecution was rejected by the Obama administration, the framing of the superseding indictment, and President Trump's known vitriol towards the press. Who can blame him? Finally, he said the only attempts to prosecute journalists in the past were obviously highly political. Now, I said who can blame him, but that being said, I don't think that, I think this is journalism on trial. They're trying to, ignore the facts and shoot the messenger, right? But I think the facts are what is most important. And just because Assange was a conduit for receiving that information doesn't make him the criminal who's liable for what is proven and not what has yet to be proved. The prosecution attempted to show that WikiLeaks, Assange, and his lawyers believed charges were still coming. But, I already went over that, sorry. So again, they suggested Feldstein was speculating and returned to the idea that names published in the documents would cause harm, which is a main argument that the prosecution seems to be using They are trying to argue that the release of these documents via WikiLeaks and Julian Assange caused more harm than good had they not been released. But the thing is, these documents and videos, they show actual harm being done. Proven harm, not harm that's up for debate, right? So I think that's a something important to note, certainly, and to distinguish between what we know for a fact and what is still up for debate. He finishes by saying, recruiting and conspiracy are scary terms used for terrorists. By contrast, journalists direct sources, say what they need, send back for more information. If that becomes conspiring, then most of what investigative journalists do would be criminal. And that's where Mr. Feldstein ended as far as his testimony on that day. But again, trial resumes tomorrow. Pompeo and Hillary are the main actors with Assange. WikiLeaks hurts both of them bad. Pompeo must have had one of his CIA rat lines quashed because he wants Assange's blood. Let's check out some of this. Oh yeah, we are seeing that. A protester on the streets of London Another man that testified was Professor Paul Rogers of the University of Bradford. He is an emeritus professor of peace studies at Bradford University. Took the stand on the 9th of September via video link to testify about Julian Assange's political views and how they factor into the Trump administration's prosecution of Assange for publishing. Rogers viewed and reviewed Assange's speeches, including an anti-war speech in 2011 in London and a speech to the UN following the release of Iraq and Afghan war logs, as well as Mairead Maguire's nomination of Assange for the Nobel Peace Prize in 2019. Rogers concluded that Assange's views don't fall into traditional liberal or conservative belief systems, but are rather more libertarian, anti-war, and based on values of transparency and accountability. On the stand, Professor Paul Rogers talked about how WikiLeaks puts these values into practice with the war logs publications, and he contextualized the releases with changing opinions in America regarding the wars in Iraq and Afghanistan. Possibly the most important part of the whole thing, he said, was that WikiLeaks releases showed 15,000 previously uncounted civilian casualties, bringing to the American public a very disturbing aspect of the whole war. As Rogers puts it in his statement, the political objective of seeking to achieve greater transparency in the workings of governments is clearly both the motivation and the modus operandi for the work of Mr. Assange and the organization WikiLeaks. In manifestation, as is set out in the study by Professor Benkler, has constituted a wholesale alteration of accessing and making available for public information the secrets that governments wish to remain unknown to their general populations. The subject matter of the charges Mr. Assange currently faces involves strong examples dog outside. Strong examples of the clash of these positions, both in their content and scope, and in the reaction of the government. Professor Rogers, in his oral testimony, explained that these views and motivations put him in contrast with successive U.S. administrations but particularly in contrast with the Trump administration. It is clear that Assange is being opposed because of the success of WikiLeaks in bringing information to the public. This is dangerous to the Trump administration. The root of it is that Assange and what he stands for represents a threat to normal political behavior. In addition to opposing Assange's words and views, the fact that Obama didn't prosecute should to some extent be considered in why Trump is prosecuting. I think that's sound reasoning. Prosecutor James Lewis sought to undermine Assange's political views by bringing up his views on corporations and NGOs, but Rogers explained that political opinion isn't just about government leaders, that the definition of political opinion has changed significantly in the last 50 years, and that Assange has a view on transnational elites. Asked if simply being a journalist necessitated political opinions, Rogers explained that it's a complex question, that deciding what to publish and what not to constitutes a political opinion. But Lewis explained that his answers were too long, not yes or no. Lewis, who is Lewis? Lewis came out of nowhere. Lewis further sought to portray all of the prosecution. James Lewis. Lewis further sought to portray Rogers as biased towards Assange and the defense. He asked why Rogers didn't include in his statement in it which he referenced views of other experts like Noam Chomsky and Kerry Schenkman, the views of Assistant U.S. Attorney Gordon Kromberg, which defended the prosecution of Assange as a criminal matter, not a political one. The prosecution then suggested that the Obama administration may not have prosecuted Assange because he was in the Ecuadorian embassy at the time. Yeah, because that stopped him before. Lewis, was it possible to arrest Mr. Assange in 2013? Rogers responds by saying, is it necessary to be able to arrest someone to bring a prosecution? Lewis, what would be the point if he's hiding in the embassy? Rogers, well, to put pressure on him. It would have made very good sense to bring it at that time to show a standing attempt to bring Mr. Assange to justice. Lewis reviewed the same items as he did with Feldstein yesterday, including WikiLeaks lawyer and editor, suggesting they still believe charges were possible. But again and again, Rogers brought the discussion back to the wider context and the fact that the Trump administration views more broadly have to be considered. Statements by then CIA Director Mike Pompeo, then Attorney General Jeff Sessions, and others have to be part of the determination. Rogers also referenced Obama's commutation of Chelsea Manning's sentence. The Trump administration wasn't happy about that, but a commutation can't be reversed by a subsequent administration. So this could be Trump's way of responding to that. Rogers hammered home that by calling this a politically motivated prosecution, he isn't saying that lower-level federal prosecutors are acting in bad faith. Rather, he said, the influence comes from the top down. The court is in recess for lunch. And then next to testify, this guy, his name is Trevor Tim with two M's. Pay the light bill. Let me just check these comments. He did get offered a deal, but Assange rejected the deal there tomorrow. Okay, let's continue. Mr. Tim, press freedom advocate and founder of the Freedom of the Press Foundation, which advocates for reporters' rights and tracks violations to press freedom across the United States. Trevor Tim took the stand via video on 9th of September 2020 to talk about the dangers the indictment uh, is presented before and against Julian Assange, and how that poses a threat to journalists and their sources. Tim objected the indictment on the ground that it threatens to criminalize source protection and the passive receipt of government documents, as well as pure publication. He concluded that it would be a radical rewrite of the First Amendment if the government were to go forward with these charges. Mr. Tim writes in his statement, the decision to indict Julian Assange on allegations of a conspiracy between a publisher and his source or potential sources, and for the publication of truthful information, encroaches on fundamental press freedoms. Freedom of the Press Foundation has helped many news organizations adopt SecureDrop, an anonymous and secure submission system for sources to safely send documents to journalists undetected. While a largely unused practice when WikiLeaks pioneered it before 2010, major news outlets around the world make use of SecureDrop, and some of them explicitly ask for leaks of government documents. The way this indictment is written, particularly the charge alleging Julian Assange engaged in a conspiracy with source Chelsea Manning to crack a military computer password in order to remain anonymous, would make this extremely common news gathering illegal. I don't think it's an exaggeration to say this indictment would criminalize national security journalism. Material journalists often write about in print what the material journalists often write about in print do not magically land on their desks, he said. They talk to sources, ask for clarification, and ask for more information. This is standard practice for journalists. News outlets and press freedoms observers agree with Mr. Tin, going on to say that this is almost a consensus opinion among press freedom groups and media lawyers who have looked at this indictment. This is why newspapers, even those who have criticized Mr. Assange, have also condemned this indictment. Is the Espionage Act overused and overbroad? Is Donald Trump the modern-day Nixon? Trump has the most confrontational approach to the media since Nixon, Tim said. He referenced Trump tweeting 2,200 times about the press, calling them the enemy of the people. Tim said this case is the perfect opportunity for him to create a precedent to punish the rest of the media. To me, it's very telling that Trump is the first one to try to bring a case like this since the Nixon administration. And that was the 9th of September, 2020, day 3 of the trial. Again, the trial resumes tomorrow morning, Monday, at London. Yeah, people will check out my brand new tube if you so desire. I am one of the Rhodium channels on there. Brand new tube is really supporting my work, which I really appreciate. So if anybody wants to go ahead and give me a sub, I'm actually growing a lot more quickly on brand new tube than I am on YouTube. Again, I am broadcasting today from Buffalo, New York. And I just want to do an episode on Julian Assange. I will do more Assange, maybe even later tonight as well. But again, the trial resumes tomorrow morning in London, United Kingdom, in a few hours here, actually. So be on the lookout for that. And stay frosty. Thanks for tuning in. And until next time, folks.